Welcome to G Fun Facts Online, the show that peels back the layers on the world around us. When you think about the criminal justice system, what comes to mind? For most of us, it's a dramatic courtroom scene from a movie. A lawyer points an accusatory finger, a witness breaks down on the stand, and a jury foreman stands to read a heart-stopping verdict, guilty or not guilty. But what if I told you that this Hollywood version of justice is the exception, not the rule? The surprising truth is that in the United States, the overwhelming majority of criminal cases, somewhere between 90 and 97%, never go to trial. They end not with a dramatic verdict, but with a quiet, formal admission, the guilty plea. Today, we're going behind the scenes to uncover the real anatomy of a conviction. We'll trace the path from that fateful guilty plea all the way to the final sentence, exploring the deals, the reports, and the decisions that shape millions of lives. So what really happens after a defendant says, "I am guilty"? Let's find out. A guilty plea is far more than just admitting you did something wrong. It is a profound legal act that slams the brakes on a trial and fast-forwards the process straight to the sentencing phase. When a defendant pleads guilty, they are essentially forfeiting the biggest game of their life without ever stepping onto the field. They are giving up a whole bundle of fundamental constitutional rights. Think about it. The Fifth Amendment right against self-incrimination, waived. You are literally incriminating yourself. The Sixth Amendment right to a jury trial, to have a group of your peers decide your fate, gone. The right to confront and question the witnesses against you, also gone. You surrender the presumption of innocence and relieve the prosecution of its heaviest burden, proving your guilt beyond a reasonable doubt. To make sure this isn't a decision made under duress or confusion, a judge conducts what's called a plea colloquy. This is a direct conversation where the judge asks a series of questions to confirm the plea is being made knowingly, voluntarily, and intelligently. They'll ask if you understand the charges, if you know the maximum and minimum possible sentences, and if anyone has threatened or forced you into this decision. It's the court's way of asking, are you absolutely sure about this? Now the big question is, why would anyone willingly give up all these rights? The answer lies in one of the most significant and controversial features of the American justice system: plea bargaining. Plea bargaining is the engine that keeps the courts from grinding to a halt. For prosecutors, it guarantees a conviction and saves the time and expense of a trial, allowing them to manage massive caseloads. For the judicial system, it prevents a logjam that would make the constitutional right to a speedy trial impossible. And for the defendant, the incentive is powerful, the chance for a more lenient outcome. Plea bargains come in a few different flavors. The most common is charge bargaining. Imagine you're charged with a felony. In a charge bargain, the prosecutor might offer to let you plead guilty to a related, but less serious misdemeanor instead. Then there's sentence bargaining, where you plead guilty to the original charge, and in return, the prosecutor promises to recommend a lighter sentence to the judge. Another type is count bargaining. If you're facing, say, 5 different charges, the prosecutor might agree to drop 4 of them if you plead guilty to just 1. This can dramatically reduce the total sentence, especially if the sentences for each charge would have been served one after the other. But this system is far from perfect. Critics raise a serious concern: the trial penalty. This is the massive difference between the sentence offered in a plea deal and the much harsher sentence a defendant could face if they go to trial and lose. This gap can create immense pressure, potentially coercing even an innocent person into pleading guilty just to avoid the risk of a devastating sentence. It's a debate about efficiency versus fairness that lies at the heart of modern justice. Once a guilty plea is accepted, the case moves towards sentencing. But for serious offenses, there's a crucial intermediate step: the Pre-Sentence Investigation Report, or PSI. Think of the PSI as the official biography of the defendant written for the judge. A probation officer, acting as a neutral agent of the court, is tasked with preparing this comprehensive document. The investigation is thorough. The officer interviews the defendant, their family, their employers, and the police officers involved. They review court dockets, criminal history, school records, and financial and health information. The final report contains everything. It details the official version of the crime and sometimes the defendant's side of the story. Crucially, it includes a victim impact statement describing the physical, emotional, and financial harm caused by the crime. It also has a deep dive into the defendant's personal life, their upbringing, education, health, and any history of substance abuse. In many jurisdictions, this report culminates in a calculated sentencing guideline range and sometimes even a specific recommendation from the probation officer. The defendant and their lawyer have the right to review this report for any mistakes, and that's critical because this document doesn't just influence the sentence. It can follow the person through the prison system, affecting their security level, program eligibility, and even their chances for release. This brings us to the final act in the courtroom, the sentencing hearing. This is the formal proceeding where the judge officially imposes the punishment. The hearing is structured. The prosecutor goes first, making their case for a particular sentence. They will highlight what are known as aggravating factors, things that make the crime worse, like a long criminal history, the vulnerability of the victim, or the use of a weapon. Then, the defense attorney gets their turn. They'll present a plea and mitigation, emphasizing factors that lessen the defendant's blame. These are called mitigating factors, and could include a lack of a prior record, genuine remorse, a difficult upbringing, or mental health struggles. Family members or employers might even speak on the defendant's behalf. Victims often have the right to address the court directly, giving a human face to the consequences of the crime. And finally, the defendant themselves gets a chance to speak. This is called the right of allocution. It's an opportunity to express remorse, accept responsibility, and say anything they believe the judge should hear before making a final decision. A sincere statement can sometimes make a real difference. After hearing from everyone, the judge imposes the sentence. In doing so, they are balancing 4 core principles of punishment. First is retribution, the idea of just desserts. Second is deterrence, both to prevent this specific person from reoffending and to send a message to society. Third is incapacitation, which means removing the offender from the community to protect the public. And fourth is rehabilitation, the goal of helping the offender change their ways. The sentences themselves exist on a spectrum. They can be financial, like fines paid to the government, or restitution paid to the victim. They can be community-based, like probation, where an offender is supervised but not incarcerated. Or they can be intermediate sanctions like house arrest or a boot camp. The most severe punishment is incarceration. And here, 2 little words can change everything: concurrent and consecutive. If a person is sentenced to 2 5-year terms to be served concurrently, they serve them at the same time, for a total of 5 years. But if those sentences are consecutive, they are served one after the other, for a total of 10 years. The judge's decision is also guided by sentencing guidelines, which recommend a punishment range based on the crime's severity and the defendant's history, and sometimes by mandatory minimum sentences, which are laws that force a judge to impose a certain minimum prison term, tying their hands completely. So the journey from a guilty plea to a sentence is a complex, structured, and deeply consequential process. It's a path defined by the surrender of rights, the art of negotiation, the telling of a life story, and the final, solemn judgment of the court. It shows that the true, everyday drama of the justice system often unfolds not in a fiery trial, but in the quiet, methodical stages that form the real anatomy of a conviction. Thanks for tuning in to G Fun Facts Online. Join us next time as we uncover more surprising truths about the world we live in.